appreciate this opportunity and your willingness to learn about this project. I became a district captain with the Convention of States project last fall, and I have to admit that for a long time prior to that, I didn't think this was a very good idea. Imagining all that the liberals could do was a scary prospect, and my imagination ran away with me. Then I was reminded by someone that conservatism is an intellectual pursuit. It's not an emotional one. Running off on your emotions is for liberals. We conservatives study, we reason, use facts, logic, good sources to form our opinions. So I got a hold of myself and began to study this issue. And through my study, three things changed my mind. The first is Mark Levin's Liberty Amendments. Has anyone read this? Oh, a few of you, okay. I know some people got free copies tonight. I don't want to steal their thunder, but the first chapter is on, Mark Levin has made it free online. If you just Google Mark Levin Liberty Amendments Chapter 1, it pops up, and that is the most important chapter, so I invite you to read that. Secondly, the second thing that changed my mind was Indiana's model legislation to select and control delegates. And third, the application of our organization that has a unified subject rule. So that means that this convention can only be about one thing, and that's reigning in effect. So let's dive into this. Okay. Our founders understood human nature, and they knew that over time power was going to be centralized. They predicted the moment that we're in. And they left a solution for us in Article 5, Section 2. Okay. Can you all hear me? Then I'll use the mic. A little bit. Okay. Yeah, this will be better. I have heard it called the Constitutional Emergency Cord, and the solution hidden in plain sight. As you all know, there's two ways to amend the Constitution. The first way, of course, Congress proposes and votes on amendments. It has to pass by 2/3 in both houses. Then it's sent to all 50 states for ratification. 3/4 of the states have to ratify, and that's 38 states. So 38 is an important number to remember. Let's keep in mind that Congress can propose amendments anytime, any day of the week, for any subject that they want. They have no limitations. When I first presented this idea to my state legislature about having a state-led convention, he said, oh no, he said, I'm afraid of this. I'm afraid the liberals are going to do something to the Second Amendment. But look at it this way. When Obama first became president and he had a Democrat House and a Democrat Senate, that would have been the perfect time to do something to the Second Amendment. But they didn't do it. Why do you think they didn't do it?
They have the votes.
Well, in a liberal Congress, he could have, but let's say he did have the votes. Could he have gotten it through the states for ratification?
Probably not.
Yeah, 38 states would not ratify doing something to the Second Amendment. There's a congressman in Texas who says it only takes 13 states to vote down an amendment. There's a congressman in Texas who said, I can shoot 13 states that would vote down this amendment. In the second process. Second way to amend the Constitution, which we have never used before, is a state-led convention where 2/3 of the states, or 34 states, call for a convention. And that's another important number to remember, 34. The states select delegates. The delegates propose and vote on amendments. And then again, it's sent to all 50 states for ratification. This is not a constitutional convention. It's not a con-con. You could call it an amendments convention, a state-led convention, a convention of states. The purpose of this is to give states the same authority that Congress has to simply propose amendments. That's all they can do. Opponents of this would have you believe that there's no history with conventions, but actually we do have historical precedents for choosing delegates. I've been learning a lot from Rob Nadelson, and I invite you to check out his website that's up here and study that, especially the tab about Article 5. He is a professor of constitutional law, one of the leading Article 5 experts in the country, and his specialty is the original meaning of the Constitution. He has unearthed a lot of information that's not taught in schools or even law school, and he notes that the liberal academia started the runaway convention myth during the 60s. I've always thought of the Constitutional Convention of 1787 as really the first convention of states, but actually states and colonies had been meeting together in conventions for different purposes since 1689. And some of the more recent conventions they have are listed here. We also have state task force today that still use the same rules established in the conventions, where each state gets one vote and each state chooses their delegates. So the mechanism of the convention was well understood by the founders, and I think the more I learned about this, that they expected us to have these state-led conventions from time to time to keep the federal government in check. I think they would be surprised if they saw where we were now and we had never done it. Federal courts have issued about 40 decisions regarding Article 5, and each time they go to history. They go to the history of these conventions to confirm that each state gets one vote, there's no proportionality to it, and each state chooses their delegates. So in a convention, one state might send, they could send 50 delegates, another state might send 10, but at the end they caucus and have one vote on each amendment. The application process, 34 states adopt the same application, and we have an identical application here for each state. The purpose is to limit the federal government. And I will read you the unified subject rule here. It says, the legislature of the state of blank hereby applies to Congress under a provision of Article 5 of the Constitution of the United States for the calling of a convention of the states limited to proposing amendments to the Constitution of the United States that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and members of Congress. So that means this convention can only be about these matters. Personal rights and states' rights are not germane. So if people ask what would happen if a liberal state that sends delegates, if they come and try to propose liberal things, those would not be legal in this convention. The subject matter of this application is binding through the entire process. So at the moment, we have the 34 applications to present to Congress. This is now binding. No other subject can be brought up with regard to this convention. So you cannot get liberal amendments from a convention called for conservative purposes. Then we present the application to Congress. Congress has no authority to stop this process. Their only role is to assign a time and place for the convention. Our plan is to give them 30 days. We want to have 34 identical applications, so there's no hemming and hawing about different language. Present it to them, give them 30 days to set a time and place. If they don't, we have the legal right to bypass them. Indiana has passed some model legislation to select and limit delegates. So Indiana will send 2 delegates and 2 alternates. The delegates must take an oath to uphold the Constitution, the state and the U.S. Constitution, and they must abide by their instructions. They may not be a government employee or a lobbyist. We also have rules to limit them. So a vote cast outside their instructions is void. And this is the big one here. This is what got my attention. A delegate who casts a vote outside their instructions is guilty of a felony and they're going to jail. Additionally, the General Assembly's application is rendered ineffective if delegates vote outside their instructions. Other states are passing these similar laws. So far, Idaho, Missouri, Alabama, Tennessee, Wisconsin, and Arizona, that's 6 states that I've heard of. There could be more. This is just all that I've heard of. Are in the process of passing these. It's passed in one house and/or is in committee in another, but it's in the works. And I'm sure a lot of you are aware of what Senator Long has been doing, working with the States Assembly. They are recommending that all states pass these laws. So once we get to a convention, there's going to be no winging it. Everyone's going to be agreed ahead of time on what the process will be. So let's summarize the controls that we have in place. We have the laws being passed to control delegates. We have the states adopting a subject matter. And the final one, and this is the big brick wall here, our founders gave us a system so that any amendment that is passed has to be the overwhelming supermajority of the people, ratification. 38 states must ratify the proposed amendment. So let's look at the political landscape of our state legislatures. Currently, Republicans dominate. Republicans hold both houses in 27 states, and that does include Nebraska, which is unicameral and nonpartisan, but it's Republican territory. Additionally, Republicans hold one house in another 5 states. So we have to get 38 states, or more specifically, 2 houses of 38 states to vote for this amendment. It is hard to pass an amendment. On the other hand, it only takes 13 states to vote down an amendment, or more specifically, just 1 house in 13 states to vote down. So passing amendments is hard, voting them down is very easy. So it's unrealistic that an errant amendment can make it through this process. It takes a wild imagination, which I admit I used to have, to think that state legislators are going to choose delegates, and those delegates will go to a convention, defy their agenda, risk imprisonment, ruin their reputation, and propose errant amendments, and then when it comes back to the state legislature, they're going to vote for the thing they didn't want. So it defies common sense. Let's keep in mind, Congress is a runaway convention every day. That's the worst runaway convention of all. Let's go over some amendments that would fall under this subject matter. The most popular, balanced budget and term limits. I agree with you, Mike, on the term limits. And Gallup says that 75% of the American public is in favor of these 2 amendments. And the first thing people ask is, come on, Diane, why is Congress going to pay any attention to these? Well, let's talk about term limits first. And we're suggesting 12 years. How do you get on the ballot? Who runs the elections? The states do. So if it's unconstitutional to run longer than 12 years, the states don't put them on the ballot. The states do have the power to pull some of this back. Secondly, the balanced budget amendment has to be written so it has some teeth to it. We want to make it unconstitutional to spend more than you bring in. And I think in Mark Levin's book, he suggests a 4-year grace period that they have to balance the budget. After that, if they don't balance it, those folks are not eligible to ever run for office again for the rest of their life. And again, who puts them on the ballot? The state does. Along with a balanced budget, we need limits on taxation. There is another group organizing, like our group, that is for a balanced budget amendment only. And that's all well and good if they get it, but of course Congress can balance their budget by inflating our taxes. So we need tax protection as well. That's why I joined this organization over the other one. We're suggesting prohibiting the VAT tax, no death tax, and these things also are popular with the American public. Repealing the 17th Amendment, where senators are voted by popular vote. Limitations on executive order, I don't think that needs any more discussion. Protecting the vote, requiring an ID to vote in a presidential election. And here again, 80% of the public supports this. Term limits on Supreme Court justices. In the founding era, Supreme Court justices were appointed at an average age of 45, but they had a life expectancy of about 52. So their terms were naturally short. They were never intended to have the generational influence that they have now. Overriding Supreme Court decisions, that's the ultimate nullification. Here, 3/5 of Congress, 3/5 of states can override a Supreme Court decision. If we had this in place already, we would have had enough states to override alone. So these are the types of amendments that would be permitted under this subject matter. And there's more, some other ideas in Levin's book. A second objection, or actually, since I've been doing this, there's several objections that keep popping up as to why this isn't a good idea or why it wouldn't work, so let's go over those. The most prevalent one, the federal government is not currently following the Constitution and will not follow any new laws. The Constitution is the only framework that Congress has, and it's true they are not following it as it was intended, but it has been expanded by the Supreme Court. So we are now living with the Constitution as it was intended and the Constitution as it has been misinterpreted by the Supreme Court. The Welfare Clause and the Commerce Clause are the two most abused clauses in the Constitution, and a large portion of our debt relates back to that. So some tightening up of that language to make it more clear as to what the founder intended could correct that problem. The 13th, 14th, 15th, and 24th Amendment all corrected state abuses of power. They're all in effect. The 27th Amendment limits congressional pay raises, and I think we would all agree not enough. But it is being followed. The 22nd Amendment limits presidential terms. It's still being followed. Women are allowed to vote. Have you seen any women not allowed to vote? That's still being followed. So history shows that government has a way of following amendments. For an amendment to pass, there has to be a groundswell from the people, and after that groundswell, politicians tend to follow. That's what history shows. Second objection, the Constitutional Convention of 1787 was a runaway convention. This idea was put out by liberal academia in the 1960s, and you all probably know the story. We had the Articles of Confederation, then we had the Constitutional Convention. They pretty much tore it out, threw it out, changed the ratification process, and that's how we got the Constitution. But leaving out certain details changes the narrative of the story. And what's happened with this story reminds me of what's happened with the story of Thanksgiving. And if you've read Rush Limbaugh's book, you probably know what I'm talking about. But the story our children are taught in school basically is the Pilgrims came over, they tried farming, it didn't go well, the Indians helped them, they had a big celebration. That's the gist of it. But to get the whole story, you have to go to the source documents, and that's William Bradford's journal. In there you get the rest of the story where the Pilgrims came over. They were so concerned about survival, they set up a communal system because they thought that would work. They wanted everyone to survive. Well, it didn't work. People saw their neighbor being lazy. They didn't want to work either, so it wasn't prosperous. Crops failed. They starved. So William Bradford established property rights. He gave each person their plot. You eat what you grow. Well, everyone was motivated. They worked hard. They prospered, and they had so much that they had enough to share, and they had a big celebration. So do you see how leaving out some details changes the narrative of the story? Why do you think liberal academia would want to tell their version?
They oppose property rights.
Yeah, they don't love property rights, and they had to cover up the failure. They had to cover up the failure of communism. And yeah, they didn't want to show that people are better off being self-sufficient. So let's go back to our 1787 convention. And here again, you have to go to the source documents, and I assure you it's very tedious. Congress limited the Convention of 1787 to amending the articles, but they did not limit the subject matter. They did not limit the number of amendments that could be made. They didn't say you can't change the name to the Constitution. When the founders drafted the Constitution, they sent it to the state, or they didn't, actually we're going to go in the weeds here for just a minute, so stay with me. They did not send it to the states as is commonly thought. They sent it to Congress with two recommendations. They said, approve the Constitution itself and recommend it to the state legislatures for a new process of ratification. And this is usually what's left out. Congress then sent the package to all state legislatures, and all 13 states approved the new process. So it was perfectly legal under the Articles of Confederation. Even Rhode Island and North Carolina, where the conventions initially rejected the Constitution, voted to approve this new process. So it was all perfectly legal under the Articles of Confederation. The states gave the delegates broad powers and told them to render the federal Constitution adequate to the exigencies of the Union. So there was no runaway convention. There is no reason to fear it will happen again because it didn't happen in the first place. It's inconsistent to say that the Constitution is the law of the land, and it is also illegal. And it is a libel against the founders to say so. I believe in the Constitution as it was written, including Article 5. The third objection, state legislatures cannot be trusted any more than federal legislatures. As I mentioned before, state legislatures are the most conservative institutions that we have in our government right now, but that doesn't mean we can trust them, of course. While we can't trust lawmakers, we can trust the grassroots who live close to the state lawmakers and can work with them much easier than federal lawmakers. And as Tea Partiers, isn't that what we want to do, is to return the power to the states? Yes?
Could that benefit by an added statement, especially if they have a supermajority?
Oh, yes, actually. And you know what, I did forget to mention that. Yeah, we do have a supermajority, and according to polls, we are going to get 6 or 7 more state legislatures in the Republican column in the next election. Yeah, that's a good point. Thank you. Most states, actually 49 states, already require a balanced budget. 37 states have term limits, and a majority of states have already passed legislation to nullify or resist federal power in one way or another, whether it's refusing to set up an Obamacare exchange or nullifying a federal gun law or any other number of ways. So it only follows that most states are going to want to pass amendments that bolster federalism. Because if they're already limiting themselves, doesn't it make sense that they're going to want to limit the feds as well? Now this last objection is one that's just popped up here real recently. Has anybody heard, oh, George Soros is involved in this, we shouldn't do it? Okay, so let's talk about what's really going on here. And I think what's happening here is, as in many other cases with this issue, there's a knee-jerk reaction to fear. But we need to look at the political reality of what's going on. George Soros is involved with a group called Wolf PAC. It's a political action committee. They have a single subject amendment, where ours is a subject. They have one thing they want to do, and that's to overturn Citizens United. Citizens United rules that corporations have First Amendment speech protection and can contribute to campaigns. So far, it has passed in Vermont, and this is the application right here. And like ours, it has to pass in 34 states. There's some information floating around the internet, and the internet is just the Wild West right now. Anybody can have a blog and say anything they want. People are sitting around that our group and this George Soros group are working together to trigger a convention. And that if they get 10 states to vote on their application, and we get 24, that's the 34. That is not true. We have to get 34, they have to get 34. So they have passed theirs in Vermont, and California's next. They're likely to get some more liberal states, and you'll probably see more of the scary videos coming around. But let's consider, would red and purple states ratify an amendment to overturn Citizens United? If you look at the political landscape and the political reality, it's virtually impossible. Before Citizens United, 22 states prohibited corporate expenditures on political campaigns. After the Supreme Court ruling, 21 of those 22 states amended their laws to comply, so there wasn't much pushback there. Already, 28 states permitted corporations to spend money on political campaigns, so they were in support of Citizens United. So there are not the numbers here for them to get 34 states to want to overturn it to apply, and another 38 to ratify. George Soros, we get a real knee-jerk reaction. He's what does Glenn Beck call him, the spooky dude? We get real scared when we hear his name. He controls big cities and big government. He does not control states, state legislatures, and he does not control the people. I am not afraid of George Soros, and you shouldn't be either. Our national leadership consists of Mark Meckler, who you've probably heard his name, co-founder of Tea Party Patriots. He left Tea Party Patriots to form Citizens for Self-Government. Convention of States is a project of Citizens for Self-Governance, and it is privately funded. Between Michael Ferris and Rob Nadelson, they are the legal people behind this, and they're the ones who have drafted all our legal documents. Michael Ferris is basically the attorney who has made homeschooling legal in all 50 states. He's the founder and lead counsel for the Homeschool Legal Defense Association for 30 years. You may have heard several months ago of a family from Germany who went to Tennessee and wanted to homeschool their children. Obama was going to deport them. Michael Ferris was their attorney. He had input into the Hobby Lobby case. He is a U.S. constitutional lawyer, a senior fellow for constitutional studies. He has argued in the federal and Supreme Court and won regularly, usually pertaining to religious liberties. He's one of the few attorneys who has ever litigated an Article 5 case, and he has done that in the Supreme Court and won. So between he and Rob Nagelson, they know how to write our documents so they're clean and crisp, and we aren't going to have any legal problems. Michael Ferris is also the founder and chancellor of Patrick Henry College. That's about a 15-year-old college in Virginia that caters to homeschoolers. It's kind of like a Hillsdale, it turns out, young conservatives. This is where our future leaders are coming from. Other colleges might have their football team that they're proud of. They've got their debate team. He is also an ordained minister, and since apparently he still had free time, he and his wife have homeschooled their 10 children. We have received some pretty big endorsements of late. Colonel Allen West said this honors the 10th Amendment. Sarah Palin suggests voting for state legislators who will call for a COS. Senator Tom Coburn said it's time for the people to take back their country. Governor Mike Huckabee said he has reviewed our plan, and I will go over our plan here in a minute. It is innovative and realistic. Senator Ron Johnson said our nation's problems will not be solved in Washington. Washington will never give up its power. Glenn Beck has reviewed the plan and said it's the only way back. Other endorsements, Rush Limbaugh, Mark Levin. A week or two ago, both of those men had long segments on their radio program about Article 5. Sean Hannity, Stephen Forbes, George Will, Greg Garrison calls it a game changer. And I might add, all the Founding Fathers endorse this, because the Constitution likely would not have passed without this provision. The status of our application, this organization is less than a year old, and already we have it passed in 3 houses, in 3 states in both houses, Georgia, Alaska, and Florida. There's another 10 states where it's in committee, or passed in one house, maybe on the other, and some variation of that. Next year we have 20 states in our site. The year after we want to finish up and get the total 34. We will be ready for a convention 6 months after that, and then 6 months after the convention, ready to send for ratification. Our grassroots organization, Michael Ferris has experience with his homeschooling in all 50 states, so he has a good plan. We want to have a viable political operation in at least 40 states. Remember that you need 38 to ratify. We would like some cushion. District captains in 3,000 of 4,000 of the state houses. About across the nation.
Mooresville Web chose to visit and use the library this evening. This is a reminder that the library will be closing in 15 minutes.
Okay, I'm almost done. I'll talk faster. Okay. Across the nation, there's about 4,000 legislative districts, so we want to have an operation in about 75% of those. I'm the district captain, and what I'm to do is to find 100 people in my legislative district to call our legislator. We have phones and pens too, and tell them we want this to happen. In each legislative district, there's about 10,000 people. So if you think we can find 100 people in our legislative district who think like us, I think that'd be pretty easy. State legislators don't get very many calls. If they get 30 calls on one particular issue, that's a big deal. If they get 100 calls, they're going to know this is something that they have to do. And it is their duty to follow what's in Article 5 to bring in the power of the feds. Please go to our website, conventionofstates.com. These volunteer positions are available: state director, legislative director, coalitions director, and district captain. We need lots of district captains across the state. So after studying this, I have concluded that this is our constitutional right to redress. It is not something to be feared, it's something to be embraced, and I believe it's our duty to use this tool to restore the Constitution. And never before has it been more true that we have nothing to fear but fear itself. Does anybody have any questions? Yes, sir.
Yes, ma'am. I've been in this battle for about 35 years on local business. I put a lot of money into it, good name, by the way. But I'd like to make a comment. When you go to talk about a constitutional convention, you call it anything you want, I will tell you something. You better darn well look at the electorate. I mean, do you trust the electorate Jefferson, James Madison, James Monroe, or do you trust the electorate that elected Barack Obama twice? Now, ask yourself that to begin with. Number two, and this is very important, if we want to modify the Constitution like this, then we're saying the Constitution is broken, it doesn't work. The problem is, elected officials do not obey their oath to God that uphold the Constitution of the United States of America. I took that oath and I joined the Marine Corps 55 years ago. I got discharged 6 years later and I still uphold it today. Next of all, let's take a look at some of the founding fathers. Let's look at Dr. Benjamin Franklin, probably one of the key members. He talked about the rising and the setting sun. He thought the Republic was going to set because he thought it was going to fall apart in the convention. They meant to amend the Articles of Confederation. What they ended up doing was trashing it, starting again. On the way out of the convention, Dr. Franklin ran into his neighbor lady, and she said, "Sir, what have you given us?" He said, "Ma'am, we have given you a republic if you can keep it." Then he said something else. She said, "Well, what did you think, sir, of the convention?" He said, "Never again." They give you an Article 5 convention for one reason, in case the Republic has totally failed to get up. I do not think we're going to have many Thomas Jeffersons, who was not there with me. I don't think we're going to have James Madison, father of the Constitution, George Washington, and we're certainly not going to have Dr. Franklin there. We're going to have people like Obama's crowd, David Rockefeller's crowd, that have a lot of money, a lot of power, and some very liberal people. I like your goals, but there's a better way to reach it. It's called state qualification, authored by Thomas Jefferson and James Madison, the author of the Declaration of Independence, and the father of the Constitution, said state legislatures can modify illegal laws that violate Article 1, Section 8, and violate the 10th Amendment. And that's what we better do, because I think the people here would be good delegates, but you got 330 million other people. And if you want to see how good, look at Ferguson, see how bad it is out there. You don't have the electric we had 200 years ago.
Okay, that was a lot of questions all in one. Okay, and I hear you about electing Obama. Do you think if we had a better candidate than John McCain, you think he would have won? If you give the voters a better choice, look at all the conservatives that stayed home. He would have.
Let me just for a second. Dick, let's go ahead and let her answer, just because we want to get Richard up here next, so let's go.
No, I didn't want to. I just.
Okay.
Okay. So I've watched it in 35 years and spent a lot of time.
Okay, that was a lot of questions all in one, so I'm not sure where to start.
Let's just let her finish, and then we'll move on to our next.
Okay.
Sorry, ma'am. I agree with. I love what you're saying, but we
Okay,
have to
interesting.
get done.
Okay, I need to answer, let me finish with his question, then I'll answer yours. Okay, I think if the voters would have had a better, if the voters are crazy and unreliable, they're crazy and unreliable for all purposes. They've still elected conservatives to state legislators. I contend if there had been a better candidate, Obama would not have won. And the states have the power here to select delegates that have to follow their instructions. If you don't think this is the solution, sir, what do you think is the solution?
What was that, ma'am?
If you don't think this is the solution, what do you think the solution is?
I was already here.
I'm sorry, if you don't think this is the solution, what do you think the solution is?
Now say that again.
If you don't think this is the solution, what do you think the solution is?
Nullification by state legislature. Very simple.
Okay, there is.
With the Alien and Sedition Act, when the Congress passed that, John Adams signed it in against his own better advice and law, and you could be charged basically with treason for speaking against the government. This is a brand new republic. Thomas Jefferson was the second vice president, president of the Senate. He went to Missouri. One of the other states, Kentucky, strongly disagreed. He sent a letter to the legislature and to the governor, and he told them how to nullify illegal acts by Congress. Kentucky nullified it. James Madison, who was the father of the Constitution, because he had so much, wrote the same letter to the Virginia legislature. They said, if you want alien sedition, your states have it. but you're not going to have it in Kentucky, you're not going to have it in Virginia. It happened, and we can do the same thing. I can go through history, legislature. Just the last legislature, we have 7 10th Amendment bills that were proposed because of one
Let me
city.
shut down so people can get home.